My name is Jennifer Tharrington, and I'm an attorney at Haas & Associates. Our website is www.carolinafamilylaw.com, and this is a presentation about gestational surrogacy. This presentation is Gestational Surrogacy 101, and it's designed for patients who are just starting out in considering surrogacy or utilizing a gestational carrier in order to grow their family. So the hope is that this presentation can address some of the frequently asked questions and some of the concerns that my clients in the assisted reproduction law have had in the past to help better understand what surrogacy is, how it looks legally, and what your options may be. Since I'm an attorney, I have to start, of course, with a legal disclaimer, which is to say that nothing in this presentation is intended to give medical, psychological, or legal advice, and that by viewing this presentation, it's not creating an attorney-client relationship between us. I encourage every patient to meet with a qualified and experienced assisted reproduction attorney prior to achieving a pregnancy to make sure that they understand their options and they can make the best decisions for their family going forward. So let's just start with the basics. What is surrogacy? The word surrogacy is actually used in two different contexts. The first is called gestational surrogacy, and the second is called traditional surrogacy. The distinction between them is the following. Gestational surrogacy is a situation where a woman carries an embryo that is not genetically related to her or to her spouse on behalf of another person or couple who intends to be the child's parents. Traditional surrogacy is a situation where a woman actually carries an embryo that was created from her own egg and sperm either from an intended parent or from a donor. But again, she's carrying the embryo and the child on behalf of another person or another couple who intends to be that child's parents. Traditional surrogacy is much less common and is actually illegal or even criminalized in some states. It's not illegal in North Carolina. In fact, the North Carolina statutes are completely silent about traditional surrogacy and actually about surrogacy in general. There are no statutes currently in existence in North Carolina that address gestational carriers, surrogates of any kind, or known donors. However, traditional surrogacy is legally complicated, and in most cases, it is not an advisable option for a patient or a family to consider. In fact, many surrogacy agencies, as well as IVF clinics and physicians, will not work with traditional surrogates and will not facilitate pregnancies involving traditional surrogates. So it's very important that if you're considering traditional surrogacy, that you speak with an attorney before moving forward with that process to make sure that you understand your options and you understand what possible outcomes could be a consequence of choosing traditional surrogacy as an option for growing your family. That kind of follows to the next question that a lot of clients ask me, which is surrogacy legal in North Carolina? And the answer to that is yes. It is legal in North Carolina in the sense that, as I mentioned, our statutes are silent as to gestational carriers and traditional surrogates. Many other states have statutes that explicitly describe what the surrogacy procedures and laws are in that state, some of which actually outlaw surrogacy in general. But in North Carolina, there are currently no statutes that address surrogacy at all. So in that sense, nothing prohibits families from going forward utilizing gestational carriers. However, there is a law in North Carolina, and we call this the marital presumption law, that says that the woman who gives birth to a child is presumed to be the child's mother, and her husband is presumed to be the child's legal father. So legal action in most cases needs to be taken in order to overcome that presumption, since in a surrogacy arrangement, the woman who's carrying and giving birth to the child is actually not, in fact, the child's mother, and her husband or spouse is actually not the child's other legal parent. Is surrogacy legal in all states? The answer to that, as I've previously mentioned, is no. Some states outlaw surrogacy completely. Other states outlaw only traditional surrogacy. Some states outlaw surrogacy where there's compensation involved, but they permit compassionate surrogacy. And some states even criminalize surrogacy. So it's very important that if you're considering working with a carrier in another state where your child would be born outside of North Carolina, that you consult with a North Carolina attorney as well as an attorney in the state where your child may be born to ensure that it's a legal place for your child to be born via surrogate, and that there are legal options available to you there to assist you with the birth certificate. So So I'm going to speak from now on out only about gestational surrogacy because that is the most popular method of utilizing a carrier in North Carolina. How does gestational surrogacy work? The intended parents find a gestational surrogate or a gestational carrier either through an agency, through a program that's available at their IVF clinic, or on their own. Sometimes it's a family member or a friend. Sometimes they utilize Facebook or other social media outlets as a way of locating communities where intended parents and prospective gestational carriers may be. Embryos are then created at an IVF clinic under the care and supervision of a physician, and they're created utilizing the eggs of either an intended parent, a known or anonymous donor, and the sperm of either an intended parent or a known or anonymous donor. Those embryos are then implanted into the uterus of the gestational carrier who will carry the pregnancy to term on behalf of the intended parents. What are the legal steps when engaging a gestational carrier? So the first step where an attorney is involved in the gestational carrier process is at the contract stage. This is done before an embryo transfer takes place, and for most IVF clinics, it's also a requirement that the contract be signed before the start of injectable medications or before the official start of an IVF cycle. Around the second trimester, a pre-birth order is often also required, which is also work that's done by an attorney. And the purpose of a pre-birth order is to ensure that the correct names go on the child's birth certificate. If you think back, I mentioned that the default under the law is to presume that the woman who gives birth to the child is the mother and that her husband, if she has one, is the father. In a case where that needs to be overcome, in a lot of cases, a pre-birth order is required, and that's actually an order that's signed by a judge that orders a hospital, as well as North Carolina Vital Records, to put the names of the intended parents on the birth certificate instead of the names of the gestational carrier and her husband. If this process is not completed or it's not completed properly, the default will kick in, which will result in a birth certificate being generated that has the gestational carrier's name on it and her spouse, if she has one, on there, as well as the other legal parent. So it's very important, again, that if you're considering gestational carrier or gestational surrogacy, that you contact an attorney to make sure that you understand all of the steps that are involved on the legal end to accomplish your goals in growing your family.